have been extremely effective in certain instances. For example, we've seen in the 1980s and 1990s very important reforms of family law in Belgium after various judgments of the European Court of Human Rights found that Belgium was discriminating against children born out of wedlock. Belgium had to fundamentally reform its family law as a result. Or more recently, Belgium had to amend its criminal procedure because of a judgment of the European Court of Human Rights concerning the right to be assisted by a lawyer from the time of the first hearing by the police of a person accused of a crime. So we have many examples of major legislative reforms triggered by international human rights procedures such as those that NGOs now currently use. However, we also are at a time when the authority of these procedures and human rights bodies is increasingly challenged. For example, the United Kingdom, in what is a very unprecedented and disappointing position of the UK, has openly contested the judgment of the European Court of Human Rights that obliged the UK to allow prisoners to vote. People detained in British jails still have no possibility of voting at general elections, despite the UK having been found in violation of Article 2 of Protocol number 1 to the European Convention on Human Rights on this particular point. Russia has openly challenged the authority of the European Court of Human Rights in a series of cases concerning human rights violations in the context of the war in Chechnya. And we have other worrying developments in which states challenge the authority of human rights monitoring bodies. For example, when the European Committee of Social Rights developed a case law protecting undocumented foreigners under the jurisdiction of the states parties to the European Social Charter, affirming that undocumented migrants had a right to medical assistance and to the protection of the European Social Charter, that was openly challenged by the Netherlands and by some other states. And this is extremely troubling because, of course, it is entirely understandable that certain states consider that in certain specific instances, a human rights court or a quasi-judicial body, such as the European Committee of Social Rights, make mistakes, provide a wrong interpretation of the instrument that they are using, and basically it may well be that the state to whom these decisions are addressed disagrees with the outcome. That is entirely understandable. But that should not be a pretext for questioning what may be called the European rule of law. In other terms, the tradition we have in Europe of complying with international treaties in good faith and implementing in good faith the decisions of monitoring bodies established by these human rights treaties. So I consider that denouncing in specific instances a human rights court or a human rights treaty body or a quasi-judicial expert body and challenging the authority of these instances is extremely dangerous, because it will then authorize other states to denounce the system as a whole and even to threaten to leave the system entirely, which would be a very serious setback in the building of a Europe built on human rights. This is also why NGOs are extremely important in the follow-up to the decisions adopted by human rights treaty bodies or by judicial or quasi-judicial human rights bodies established within the Council of Europe or within the UN. It's vital that NGOs take seriously their role as watchdogs so that they force governments to take into account the findings made by these judicial or quasi-judicial bodies. Without these NGOs, without the very precious monitoring role of civil society, it would be very difficult for these judicial or quasi-judicial instances to have their decisions respected and implemented by the states concerned. And so once you obtain a judgment, or once you obtain a decision from a particular human rights body established within the Council of Europe or the United Nations, the fight only begins. The follow-up then is to be assured, and the NGO should pursue its efforts to convince parliamentarians, to convince governments to reform the law, to change the practice in order to implement the findings that were made at international level.